So moving on, our next speaker for today is Ms. Chitra Iyer, Director, Licensing Program Leader at Philips. Interestingly, Ms. Iyer was a scientist doing molecular research for 10 years before moving into the field of IP and law. Her areas of expertise now include IP strategy, portfolio management, transactional matters, IP litigation, to name a few. She has held leadership positions for the last 17 years in various MNCs in India and Europe, and in her current role at Philips, she is responsible for developing and growing licensing practice in India. Notably, Ms. Iyer was involved with the first SEP verdict ever in India and also was involved in cases revolving the highest damages so far in copyright, designs, and trademark matters. Today, Ms. Ayo will be talking on maximizing corporate IP value. We're extremely pleased to have you here with us today, ma'am, and request you to kindly take over.
Hey, thank you so much, and I hope my audio is okay.
Yes, ma'am, we can hear you perfectly fine.
Thank you. And personally, I think I always enjoy a lot talking to faculty and students. I think it's always enriching for me because students usually come up with such excellent questions which are thought-provoking, and I would never miss an opportunity where I could talk to students, for example. So thank you so much. And let me, so today in today's talk, I've kind of, I'll start showing my slide. Hopefully it's working properly. Uh, okay, I think I'll put this and share, and I hope it works. Is it okay?
Yes, ma'am, we can see your presentation.
Yeah, just 1 second. I'm trying to adjust my setting here so I can also see the screen. I think, okay, now I hope. Right, so today's talk is more about maximizing corporate IP value. I thought because Dr. Sarkar also told me that the audience today is likely to be a mix of corporate and students. So I try to have a mix of both in my talk. So there is something and somebody in my talk for everybody, either to come back to me as a feedback to discuss further, or to somebody who's a student who would like to work in a corporate setup to give you a flavor of what really happens in a company and how do we go about things. So I'll talk a little bit using my own company as an example, and to give you a little bit of background, we have been prolific filers of IP in different forms, be it patents, trademark, copyright designs globally. We've been in Clarivate's earlier, it used to be Thomson Reuters, the top 100 innovators. So this year, I believe we got the award for 9th year in a row. We also file a lot in India, and that means that we have a lot of focus on filing IP. But that doesn't happen just by a simple decision that, oh, I want to file IP, right? There's a lot of things that we need to do internally, including convincing our management. And convincing the management is also not always easy because you have to show results at the end of the day, right? So we are all very accountable. I'm sure everybody is. But in a corporate, for example, it's a lot more rigorous, So moving on to the next slide, please confirm that you can see the slides so that I know that they're moving properly.
Yes, ma'am, it's visible.
It's visible. Great, thank you. So I have around 19 odd slides, but they're all 1 to 2 minutes each, and hopefully I'll be able to finish during my stipulated time. I'll talk a little bit about Philips as a company and background of what we do and why. So our focus areas of focus and how do we determine a business strategy, for example. What is expected by our senior management, our stakeholders, and how does IP contribute? I thought I'll include this slide because usually I've heard a lot of people, IP professionals, asking about how do you convince management about filing more? How do you convince them about value of IP because they don't understand, you know? So that's a thing, that's an international topic, in fact. So I thought I'd just include a little bit on that. Intellectual property in the package. I'll come to that in my slide. What is integrated asset management? When you have different types of IP, how do you manage them together to maximize value? Integration of IP into the classical stage gate model. IP strategy implementation of the OODA loop, and we'll talk about what this loop is. Corporate IP portfolio management, patent versus trade secrets. How do you make the decision? It's a judgment call sometimes. Handling of inventions, how is it done in-house? IP business models, challenges associated with remote working of employees, because that's what we're going to be speaking today. What are trade secrets as per TRIPS? Trade secret versus confidential information. IP risk due to delay in prosecution, and what happens when there's delay in enforcement for a company. Okay, of course, that's a problem for everybody, but we usually have knives hanging on our necks in the corporate sector. So we have to be very vigilant and alert most of the time. So I'll go to the next slide. So as I said very briefly, I kind of feel that I need to talk about this as a company which has invested heavily in R&D. We are stakeholders in the ecosystem. We are stakeholders in the IP that's been generated. We are stakeholders in the IP advocacy that happens. Be it the computer related invention order that the new rules that came in 2016 to the new IP division to what have you. Philips as a company has been heavily involved in working with the government of India, working with the government of other countries to ensure that we have an ecosystem that's mutually conducive to everybody, to the companies, to the individual inventors, to the startups and everybody, because we have the responsibility that we have the know-how, we know how to do it, and it becomes obligatory that we also advise on what best way to take things forward. So this is typically a number that I have here, 1.8 billion invested back into R&D. That's going to be the bread and butter for all of us in the IP profession. Then around 860 new patents. A few years earlier, around 2015-14, it used to be close to 2,000. We have kind of rearranged our own portfolio and trying to maximize value from what we file, and therefore you see a little bit drop. But we're trying to improve on the quality aspects. It's getting better and better and more enforceable patterns with every new filing that we do. This year, I understand we are in the ninth consecutive year of being the Derwent's Top 100 Global Innovator. And one out of two R&D personnel is either coming from a software or a data science background, because that also shows that this is the direction as a community, is where we are all going towards. We are moving into technology, and that's indicative of that. Around the current portfolio is 57,000, but there was a time 3-4 years back we would have a portfolio of 80,000. Few have been abandoned, etc., which is a part of the corporate strategy. And then we have been listed as the first medtech company in Boston Consulting Group and top 50 most innovative companies. So just a bit of a background on the organization. But importantly, I think what I mean to say by all of this is that the company. So if you think, those of you like who come from my generation might remember that one of the first Walkman that I used to have those days when I was in college used to be a Philips Walkman. I used to be so proud of it. It was a music system. Even before that, I think if I speak about my parents' generation, they would probably relate Philips to a tube light or a light or a bulb. The current generation of youngsters, there's a lot of them who use either the Philips trimmer, they use the hair curler, or people in the kitchen who like to cook, they must have seen the Philips mixer grinder, for example, and they may think that, oh, Philips does this. The reality is and truth is that we have over the years constantly innovated ourselves to do what is relevant for the market that we serve, what's relevant for the customers, what is it that people want from us, what would the customer buy, for example. And right now, I think for the last 2 years, not only have we been more heavily in the medical equipments, with like ultrasound, MR, CT, what have you, but also into trying to be how do we serve people who don't have access to these healthcare professionals. Like it's maybe it could be remote monitoring of older people. It could be remote monitoring of sick people who are not able to travel to the hospital. How do you do telemedicine? How do you do, how do this? In India, we have limited number of doctors, and I heard the speaker before me excellently articulate, the deficiency we have in India. So we have a certain limited number of healthcare professionals, and we have so many patients. How do we address those requirements? How do we take care to everybody, right? So things like that. So behind all of this, there is IP, there is innovation, there is IP, and before all of this is the corporate strategy for a company that believes that we need to do something, as a part of what the customer would need or benefit from. So currently, when you see our strategy is most about working in the different aspects of healthcare, that is healthy living, starts with maybe the juicers that we have or air purifiers to prevention. That could be in terms of, again, air purifiers or the ventilators or whatever different devices that we have. The diagnosis, ultrasound and MR, there are CT that come into this area. Treatment, how do we make sure that the patient is getting the best treatment? Because diagnosis is related to treatment in the end. And then home care, that once you've gone back to your home, how do we make sure that you continue to stay healthy and get better after you're maybe discharged from a hospital or a procedure? So behind all of this is also an IP, and we kind of make sure that we are focused into what the company strategy is towards how where the company currently believes that this is where we need to focus. So we divested a lighting business a few years back. A few months back, we divested our domestic appliance business, although we still have cross-licensing arrangement with both these organizations, or different arrangements with them where the Philips name is still used in the products. But most so we are now focusing on the healthcare industry, and we have innovated ourselves. Apart from innovating for the markets, how do we be relevant in present day and time? So the next slide, going on to what is expected by the stakeholders. Our stakeholders here we say are the shareholders of the senior management, who have a certain mandate. They believe certain things are where the company needs to focus on. But however, one thing that they're usually very clear about is how do we realize a higher price? How do we grow and capture market share? How do we maintain a lower cost? How do we leverage on our assets? And from the IPNS organization, we try to see how do we fit our own agenda into what the company is driving towards. So for realizing higher prices, for example, we will look at how do I build brand loyalty and invest in new product development, maintain product or feature exclusivity. How do we ensure that there is licensing revenues? Um, and to grow and capture, protect, and market share, grow market size through licensing. We can maintain market exclusivity by defensive litigation or offensive litigation, for example. Maintain lower cost, access to technology, in-license acquisition, for example. Avoid exclusion, resolve or avoid litigation is when you are proactively making sure that you don't end up on the wrong side in the court, and do what is needed to be done to make sure that you are also complying with what you're asking other people to comply. Leveraging assets, raise capital, support exit strategy, enable joint ventures. All of this is something we as an IP organization can always support. And the discussion that many times the question is how do we get the management to hear that we need an IP department or we need funds for the IP department, is usually the best way is to talk their talk and see how you can add value. Because if you need to if you need to negotiate for a department or a team within the setup that you have, you will have to show that it's a win-win for both, and that's the only way that you can get the eyes and ears of the management to hear what you're saying, and that's the harsh truth. So if we go to the next slide now, intellectual property in would already know that when you take any single thing in your hand, a device or a product, there are components of IP that are already there. It's rarely ever one single IP. If you take a cell phone, which I've used as an example here, you will have the trademark. If it's a Nokia or a BlackBerry, or if it's a Samsung or a Apple, you will identify the phone. So when you go to the shop, preferably you will ask for the phone by a brand. Then you look at the specification, which is covered by patents. Then you look at the brochure, which talks about how the phone is to be used. And then there will be, of course, brochures associated with copyright, because somebody's used their intellectual capability to write the brochure, for example, in a certain way. So when you purchase something, all the different types of IP are involved in one particular device that you're looking at. And of course, there is the design aspect of it. A lot of the youngsters today, they like to have phones they have different colors, they have different look and feel. So sometimes customers don't look just at the technology or the trademark; they also look at how does it look. So it has to also look good. It has to look contemporary. It has to look as per the demographic that we're planning to sell it to. The customer holds the key to everything. And based on that, these designs are done when we're developing the product. So we have different types of IP. We have patents, trademark, design, domain name, also trade secret and copyrights. Now, a lot of people, they sometimes overlook domain name rights, but it's quite a tricky thing, because we have seen instances where the way people doing cyber squatting, as you may call it sometimes, using the Philips website name, but that the moment you would click into it, it would go into a different site. So this is misusing somebody's domain name, or creating a domain name which is very misleading as to another established brand with a well-known brand value. That also is possible. So one has to plan your IP accordingly. When you start with a new product, for example, in the market, you would look at what makes sense. More importantly, do you just need to file for patents? Do you need a trademark along with your product because it's so unique that it needs to have a separate brand identity? For example, if you talk about Philips, we have the larger brand name Philips, which is very well known. It's a well-known mark by itself. And we have sub products within it, and we would name them differently sometimes. For example, we would have the Sony Care, which is our electrical toothbrush, has got a different name within the main brand. Then there is the Event, which is the baby product market, because sometimes customers identify not only with the main brand but also with the sub brand within the brand. And then at those stages, we have to think about, do I need also a different trademark for this product? Do I need a different design, And sometimes if there is a design infringement, or you want to make it easy for your for your marketing people to sell, you may want to also give them an advantage where customers sometimes get, they get swayed. They're not sometimes capable enough to identify the technology, or they may not be interested in looking at the underlying technology. They may just look at the color, the shape and everything, and they may decide to buy one product versus the other. So we need to innovate in our designs to make it, as I said, current. And then, of course, not everything is patentable, not everything is protectable as per law. Some things are all excluded as per the Patents Act. And those kind of information will typically be protected as trade secrets, especially if they have an economic value. And I'll talk a little bit more about trade secrets towards the later part of my slide. But essentially, IP strategy management. So we may not do everything for every product. We may pick and choose as to what makes sense and where should we spend our money, because that thinking process and qualifying the thought by taking third-party feedback, by talking to the business and marketing is very important, because then you do something which is really recognized by everybody or the stakeholders to be something that's going to be important to invest in. So let me go to the next slide now. This is for people who don't really have a feel for what happens in house. The people who are already working in corporates, I'm sure, are very aware that everything happens in a stage-gated way within the product development cycle of a company. So you would have first the idea screening, initial scoping of the idea. Then there is a commitment that comes from the management that it's worth investing in that idea and that product should be developed. Then you go on to the development stage. Then there is the launch, and that is go to support the after service and marketing, etc. So the IP aspects of it trigger in different types of IP aspects trigger in different stages of the product life cycle. And an in-house IP department or an external lawyer, if you're hiring an external lawyer, is brought in at different stages to manage this. Or ideally, they should be brought in, because that way we make sure that you don't do something that's going to be a very costly mistake. A lot of times, people assume that they don't understand IP. They wouldn't like to understand IP, and therefore they just rush into things without giving importance to a very important aspect. Because believe me, the litigation costs can really go skyrocketing if they don't focus on these things right in the beginning. And the more I say, it's less, because being an active litigator, at least for the last 6-7 years, I know how much it costs. So that's why it's very important. When you have an idea screening, it's important to do a prior art search. You may not always get a 100% green signal, but more importantly, it's important to have a fallback strategy as to, how are you going to manage it in case you're going to be receiving a notice letter, for example. What is your answer? Do you have an answer or not? So things like that. Then you need to look at then you have to agree with your management that you're going ahead with the idea. You would do a broad pattern screening. You would look at the competitors in that space. You would look at how viable is this idea. Is it cost effective? Is it easy to manufacture this in a scaled up manner, for example? And then prepare for the filing at that point in stage. And then you have to decide what are you going to file, why, which countries, and etc. Right? And what kind of patents are you going to file? All of it. Now, after this, usually before the launch of the product, it's highly advisable to go into another full-scale FTO search. And then once it's launched, again do periodic searches. At that point, you probably need to check if anybody else is infringing your trademark or your patent or your design, for example, and then take appropriate action if you have to safeguard your IP. And then then once you go into the go to support stage, so there are different nuances. At that stage, you may acquire either new licenses, you may acquire software licenses. A lot of times it's assumed that open source is open, but it's not always open. So looking into the licensing wordings of the licensing agreement, making sure that they are okay to use in a product commercially sold in the market, all of that needs to be done at that stage. So this is what typically happens. For those of you who already are in the corporate, I'm sure would know this very well. But I thought for the students who are new to what happens in the corporate, or those of you who aspire to be in the corporate, this is something to be very cognizant of. Now, let's look at what happens in the OODA loop. Is the typical connect to the ecosystem, because you don't work in silos. We work in an environment which ideally needs constant interaction and dialogue with the external market. So that's where the customer is. And also do what your internal stakeholders are okay with doing. So when you do this, for example, here you have in the slide, we need to be mindful of what is technology environment, because if you are moving towards 5G or 6G, and you don't at that point of time go to a 2G kind of technology, right? That's going backwards. Since if we are a country that's already adopting 3G and 4G, it would be in fact not a good thing forward looking to adopt a technology which is already much older and it has advanced beyond that. So you have to look at the technology environment. You have to look at the customer need, which I think the lesser there's the more I emphasize, it's still less, because we exist because of the customers. We exist because there's somebody who has a requirement at the end of the day, and it has to match with what people want, what the customer needs. And then we have to see what are the other competitors doing, and you don't want to end up doing something similar, because otherwise you'll end up litigating. Also, you want to make it differential from your competitor or give it a different twist. There are solutions in the market which address a particular need in a particular manner. You can always introduce things which are variations to that, or different or advancement to that, for example. And keeping a watch on the competitor is always very important, I think, any way possible, because they could be your future collaborators as well. Or they could be somebody who could be you may be litigating against them, or they may be litigating against you. But in any case, good to be mindful about which technologies are being used externally. Partner ecosystem, legal environment, because changes in legislation, changes of laws, changes in the tax system, changes in labor, everything is important when you're doing business. It's important to have an eye and ear on all that's happening in the external ecosystem. Then we observe this, when we say we have all these factors coming in, there's surveillance of what's happening, understanding what's happening, what's changing. And then there's internal monitoring. I'll give you an example, for example, of a company which is involved in a healthcare business. Predominantly, it's importing spare parts, for example, from some other countries from externally, because the cost is working out well. At some point of time, the excise duty or the import duties are going to be so high that it's not viable. You should, a lot of these things are anticipated before they actually happen, right? We would get to know probably by feelers a year or two before that something is going to happen on that stage. You would almost better start manufacturing or thinking about local manufacture, because those escalated excise duties or import duties or whatever, they could really derail your whole plan, right? Your profit margins will go really down, and then you would start running under losses. So the external environment is very important to keep a view on. Then once you have all this information, there is surveillance. There's internal performance monitoring, because despite all of this, there'll be a group of internal stakeholders and shareholders who may still want to have a certain direction in mind. They have a certain plan, so it has to be discussed along in line with that, and whatever you're going to do has to be meeting not only the external environment but also matching what the stakeholders want. And then within the internal R&D, we have the innovation protection leveraging, which is done by the R&D and IP department together. And then there are the other things that flow in from top, right? The corporate strategic plan, as we discussed about the business unit strategic plan, because if there are a company, there are many units within it. Each unit might have its own agenda and a target and a goal. And you would have that, and then there is an IP strategic plan that actually helps these businesses to achieve the objective. Then based on that, you have the priorities and objectives which fit into everything, and then there is an orientation of everything together. So together with all of these things don't happen in a step-by-step manner, rather they happen in a cyclic manner, at the same time, all the time, right? So this loop has to be on all the time in order to maximize what you are able to do as a IP group that supports a corporate objective. So this is again typically what happens in an IP department. You have a mandate to have an IP portfolio, and there are different ways in which you will probably accomplish it. One will be through the own R&D, in-house the R&D that you will have within the company. And in-house IP generation can also be outsourced sometimes. And I heard questions from the previous session. There were questions from people asking, how can you, link research innovation to corporate innovation? There are a lot of ways to do that. In fact, my personal mandate has always been, how do we make sure that we give an outlet for the R&D that's happening in India. And if anybody wants to have this conversation offline, I'm very happy to do that, because if we can work together to do something that's working for the industry, working for the research in a collaborative way, I think that's a real win-win for any company to engage in. Okay. Then IP acquisition is another way where we don't wait for infinity to generate the same R&D. Sometimes it's available with other organizations or companies or R&D centers or institutions. It's easier to just qualify that IP and take it in. That's IP acquisition. Sometimes it's joint development, because then we have a certain thing to accomplish, and there is know-how, there is capability in certain institutes. So we work with them to do this. We have collaboration with several hospitals in India, for example, also globally, where we work with the hospitals too, because hospitals have a better inflow of patients. They have a better feel for what the customers want. Either customers could be doctors or patients in this case. And we work with these hospitals and institutes to develop solutions that may be useful for people. Then keeping in view of open access and innovation is very important. And sometimes we cross-license with competitors or collaborators to maximize each other's market presence. And then there is in licensing also, not just acquisition, which is purchase of entire IP, but in licensing is just taking a non-exclusive or sometimes exclusive license from people who have that IP. Okay. Important question. I think so. Do you always need to patent? The answer is no, and you should not. Right? There are certain qualifiers for that. Is that if you're there are a few things that every patentable invention should have. One is that it has to be enforceable. It has to be detectable, and there should be need for that IP. All these things is very important. And it's easy to detect, then of course we should file a patent. Sometimes it's difficult to detect, but it's a very important innovation. Then we still can keep it as a trade secret. Otherwise, it's a judgment call. Sometimes it's not worth protecting. If it's non-patentable, you can't protect it anyway. and sometimes we may not choose to keep it as neither as a patent or a trade secret. But more importantly, when you're filing something, it has to be enforceable. It has to be detectable, because if it's not detectable, you will not have any evidence of infringement. If you don't have evidence of infringement, you cannot prove infringement, and it's very less value for that IP in that case. But if it's still important for your organization, you should still protect it as a trade secret. And how do you protect it as a trade secret? I will explain very briefly in the next few slides. It's a topic, very broad topic, but I'll try to simplify it for the session. And now, handling of inventions usually goes through a screening process. Ideally, it should. Once the innovation is submitted, there's an assessment as to whether the innovation is patentable or not, novel, non-obviousness, or non-obvious and inventive. There should not be any prior art, which is novelty destroying. Do the prior art search and decide to go ahead. But if there's prior art, you may have to reject it. If everything is okay, you draft and file a patent applications, and decide which countries you want to file it in, and then it gets filed, and then you're the owner of that patent. Um, so then the next slide now, if you have the patent now, what do you do with it, right? That's very importantly, why do you file patents? So you have to file patents when there are 4 or 5 reasons, as I listed in my screen. Either it has to increase your profits, as I show here, or it has to be a cost saving objective. And how does this happen? The more importantly, you file IP because you will be able to develop solutions which are going to have which will enable you to get premium profits in the market, right? How you can command higher. For example, look at Apple phones. Now, Apple phones are not the ideal example. The only reason I take example of Apple phones is because the technology that they adopted uh, in the phones, the technology they adopted in the phones. I'm not saying it was their technology they adopted. I'm just saying the technology they adopted in the phones was new. For the customers, it seemed as new, unique, and therefore they could command a higher profit. I think you would agree with that, that the phones are priced much higher than the other similarly placed products in most cases. I'm not again commenting about the IP that they use. I'm just saying the product that they introduced in the market was having the unique, component in it where it could command premium in the market. So the higher margins are reasons why you would have IP. Another reason for having IP, good quality IP, is sometimes, as in companies, the management agenda changes, the focuses, and then you're left with a lot of IP sometimes which you're not using in your products. But if this IP is really good enough, you could concurrently or other ways license it out for good revenues. There are companies that make billions of dollars annually just from the licensing revenue. I said billions. So this is huge. But you get to this point only when you focus on generating high quality IP, which is enforceable, which is detectable, and everything else that I said earlier. So if you have that, you can generate premium profits out of your IP. The other reasons to file IP should only be when if you are looking at opportunities where you still want to be a player at the market. It's an ocean, you want to be one fish in the ocean, but you want to be the fish. Then you want to freedom to operate. You don't want others to come and litigate against you. You need to have a portfolio for that. So you would have freedom to operate. This could typically happen maybe to pharma products, which are incremental inventions, which are a bit different, not very unique on their own, but they can still sell as a different name, a different brand, and they can still coexist in the market without having a very very innovative product. They will still have a market. Same is also true for crop protection and agri products, more case where it's a very different. So you maybe a side chain is different or a molecule is different in a way, and you could still have the exclusivity if the Marcus claim doesn't cover it, of course, right? So, and then there is a mitigating model where you will have an IP. For example, you have there's a manufacturer of a bottle, a Bisteri bottle, and there's the manufacturer of a cap of the Bisteri bottle. Now, individually, you cannot go to the market because you need each other's, the bottle and the cap to go sell the product together in a market. But this is an opportunity to cross license where you say, okay, we will cross license. You sell it under the brand name of so and so, and I will sell it under the brand name of so and so. The customer is very distinct. A customer can distinguish between the both the products. They are having different trademarks, different names. You capture the northern market of India, I capture the southern market of India, and we both coexist, right? So this is how the cross licensing works. But for that, you need to have that IP. So if this person did not have the IP for the bottle, or this IP did not have the IP for the cap, they would not be able to cross license because there's no IP to cross license in the first place. So this is how IP should work, and IP should always be with an objective of generating profit one way or the other, because it's expensive, it's costly to file IP and maintain it year over year. So do it, but do it with a clear clarity of purpose, clarity of outcome, and why you're doing it. It's very important to have clear. Now, what is trade secret? Now, sometimes we talk about trade secrets, right? But what is trade secret as defined by the TRIPS agreement to which we are signatory to? Article 39 of the agreement says there are three important requirements of a TRIPS agreement. One is that it must be a secret. That means it's not something you have divulged in a conference or spoken to friends in the chai stall, or spoken about it in, in a paper or publication or something. It has to be a secret, and that's one of the qualifiers. Second thing is it must have a commercial value, right? And that's also a differentiator between confidential information and trade secret, is that everything is not a trade secret. Okay, we'll discuss that a little more. And the third requirement of TRIPS is that you should have taken reasonable steps to protect it. Okay, now what the TRIPS agreement says is that if it is that important for you, that means that you should have taken the steps to protect it. How would you do that? So, for example, certain things, especially for the academia, which is very important, which I think a lot of PhD scholars also learn, is that you have to mark, if you're presenting a slide, you have to mark it as confidential. If you're selling out documents, you have to, for internal circulation or review, it's always advisable, even as per the Indian IT Act and Evidence Act, to say confidential in your email, for example. Or if you're sending a presentation, put confidential at the bottom of the presentation, or say it is for this purpose only, right? Beyond that, if there's a theft of your idea or your innovation or something, you can at least say that you have forewarned the other party. You have indicated that it's a trade secret, and it was supposed to be a trade secret. And if the person misuses it or shares it beyond that, it's a breach of trust. Or it could be any of the other factors, which is different provisions of the of IPC that we have. But if you have not warned the other person, then you cannot go and say that, look, this was confidential information and you stole it. You cannot, you don't have any position to say that, because you have not taken the trouble to inform the other party that what you're sharing with this person is confidential. So these are the three important requirements. Now, going to this, and the reason I'm also talking a bit about trade secrets today is because we're talking about corporate IP, right? A lot of corporate IP is trade secret, and I'm also going to talk a little bit about the challenges with remote working, which exists today in COVID times, in which a lot of companies believe that they will continue to have a hybrid working model. It becomes more and more important to know how do we share trade secrets. Now, coming back to this topic, trade secret versus confidential information. Now, there must be something very confidential. For example, your friend is getting married next month. That is not a trade secret because it doesn't have an independent economic value. Although it may be a lot of value for the person involved or people involved, independently it doesn't have economic value. Therefore, in the eyes of law, it may not qualify as a trade secret. Now, therefore, all confidential information are not necessarily trade secrets. Now, a trade secret is only a secret as long as it's kept a secret. That means if you're publishing it early, if you're talking about it in a conference, although there are provisions in the Patent Act to protect certain, for a certain period of time, uh, information that has been shared for certain purposes, but doesn't mean that this is applicable to everything. You still should be ideally very careful when you talk about your patentable ideas, especially, or your ideas which are proprietary to you, uh, before you file a patent. Sometimes it could be just a process. It could be a chemical process that is already existing. You may have tweaked the temperature, pressure conditions. You may have realized that a certain quantity of a catalyst gives you better yield, for example, or you feel that certain pressure conditions are giving you better yield. So these may not be patentable. It may be very, very incremental. But from a corporation perspective, it may save you a lot of money, or give you a lot of higher profit because your yields are better, for example, right? So in this case, although it's not patentable in the eyes of law, it may not be patentable, for example, it is still a valuable trade secret to guard because it is competitive information which is competitive, which is giving you a competitive edge in a similarly placed company or organization who's producing the same product, for example. Now, note information if so of course, if you look at any agreement, there will be a certain carve outs that says that this information is not confidential, it's not a trade secret if it was independently developed. But of course, you'll have to prove that. So you'll have to make sure that if it was, that's why documentation at every stage is very, very important. A court only sees the evidence in most cases, and if you don't have good evidence to say what you're saying, however true you may be, however truthfully you may be speaking, it may not hold much water. One and same invention, patent usually excludes a trade secret because if you covered in a patent, obviously it's going to be in public domain in 18 months. So it will not, it excludes a trade secret and needs to be defined a priori for successful enforcement. As I said, you need to have a trail of evidences to show that you have developed it on your own. Going back to my lab days, I think maintaining the lab notebooks is still very, very important and relevant, and documenting what you do, very important, crucial on the day of development, not 1 week or 1 month later. And now, challenges associated with remote working of employees, as you know, is because none of it is maybe intentional. It's just the framework in which we work is that if even if, despite you having your own independent place to work, it is not your office environment. You could be surrounded by people who are not working in your organization, and you may not have your cubicle or cabin where you work. So there's going to be a little bit of traffic in and flow. It becomes difficult to manage trade secrets. Whether you're a manager or an employee, I think the onus is on both to be responsible and accountable at the end of the day. So there is going to be how's the wording of the employee agreement, for example, and you're talking to third-party customers and suppliers. They're all probably working from home environment. How do you ensure that your contract terms or your negotiation terms, your deal with this particular contract is not given to a third party? For all you know, they may be neighbors, but they may be sitting in the same room when you're discussing. It gets very hard to manage all this. Then, of course, how do you, if there's misappropriation, how do you file a complaint? What kind of information do you need? What kind of precautions do you need to take before to make sure that you have enough information to go to the police station, for example, with a complaint where you will file, the police will file an FIR. Then online systems are challenging, right? People taking screenshots, photographs, everything, what have you, and the only way to bind people is by contractual obligations. That's the only way you can bind them. But then you'll have to also have a system where you can collect evidences in this case. Security vulnerability, and many of us have assistants at home like Alexa and everybody who's, there's a constant listening in to conversations and everything, and how do you protect it? I'll come to that in a bit. There are different aspects to protecting IP. Trade secrets, especially one is from the IP department, which is by timely filing of patent applications or advising the teams to protect their trade secret. There is a legal part, which is about contractual obligations, drafting the contracts appropriately. For example, in COVID times, you may want to include certain selective provisions into the agreement which are safeguarding, considering the remote working, for example. You'll have to include those provisions in the contract. Electronic information security. How do you make sure that your employee is not divulging your information or taking it out and sending to somebody else? So one is that, of course, absolute trust. Trust is a two-way street, but again, having certain undertaking in place, having certain HR procedures, having mechanisms to detect leak in the system, for example, it's all doable. It's all exists. There are solutions to everything available in the market. Then there is physical information security. Laptop is not going to locations where it's not supposed to go, etc., etc. Printing of stuff and all of that. All of this comprise of the different aspects that go into trade secret protection. Now, what happens is there is, especially during COVID, we have seen that there is a lot of delays sometimes uh, in IP prosecution, because there were times when the patent office was not working to full capacity. There were people in the patent office who had COVID, and things were not going as fast as we would like. There was a Supreme Court order that waived, this time period, the limitation period during this time to accommodate for everybody's health situation, etc. But at the end of the day, what really happens is that there is a delay in prosecution, there's a delay in grant for whatever reason. And this can actually impact, so then you need to have counter strategies. Like, what do I do? Should I file today and let it wait in the system, or should I start protecting as a trade secret? Should I have a different mechanism for doing? So you'll have to innovate around the problems and see what can be done to do what you have to do in the process. But of course, these things do delay everything. What you could also do is maybe have all your documentation ready and prepared, and then file everything at the same time once things are more, uh, what do you say, better, things get better, more conducive, and then wait for that. But all depends on the organization and what their mandate is, and do what is appropriate. So delays in IP enforcement, being in the thick of things, recently I think the COVID has been a blessing in disguise in a way. One thing is, despite all the problems, we could have the IP division now fully functional from 29th of March. No, actually it was from last week, last Monday onwards, the IP division was fully functional. We have two judges now dedicated for this. But what happened during this whole COVID situation, something I would have never thought of 3 or 4 years back, is that the fact that we're able to have hybrid hearings, and the plaintiff or anybody else who wants to hear can hear remotely. I think the courts have just, kind of ramped up their IT systems, their tools. The judges have got trained in using these facilities, and they are able to work seamlessly with scanned copies of files, electronic copies, and that's, I think, such a huge shift. So COVID has got certain disadvantages. A lot of our matters got delayed. I'm sure everybody got impacted with the speed. A lot of lawyers were complaining because they did not have the necessary infrastructure to continue to do their work. But despite all of that, I think the positive side is that we see technology being adopted in the courts. And I think for the younger generation and the generations to come, that's a huge blessing in disguise. You can sit in Bangalore and attend a hearing in Delhi. You can sit in, wherever you can do your job where it's convenient for you and it's working for you. You can take care of your maybe aged parents or relatives or whatever, and or do whatever else you want to do, but still be able to do your job. And that's, I think, a huge advantage of the COVID. But however, there are delays in enforcement, and delays in enforcement, especially in the criminal matters, can have a very big impact, right? So that could be a problem. And I think with this, I kind of covered what I wanted to cover. Maybe, and but I'm really happy to talk about any other topics you may have, or go back to any of my slides if you want me to explain further. Um,
Thank you so much, ma'am. That was indeed a great presentation. I'm sure all the attendees enjoyed and took back a lot from it. So we already have one question lined up for you, if you'd like to take it.
Absolutely.
So, ma'am, Sayyida Fahima asks, in cross licensing, deals with competitors, what
Yeah.
are the things to keep in mind so that we don't violate the antitrust laws?
Very good question. No? It's very good question, because you do know that antitrust will kick in the moment people feel that there is a monopoly of what you're doing. Actually, I can get the context a little better. I can explain it a bit more clearly. because antitrust can kick in at any point of time, right? It can kick in during a standard essential patent, for example, enforcing a standard essential patent, because people may view it as a monopolistic thing, but in reality, it is expected as a FRAND behavior, fair, reasonable, and non-discriminatory. But if you're looking at so cross-licensing did not really be, if you see, really viewed as antitrust, unless you feel that it's going to lead to a monopolistic kind of arrangement. So when you cross license, obviously, there are going to be two parties who will benefit out of this. Two parties who will benefit out of this, and there's going to be competition among them, a healthy competition, I would say. The healthy competition usually is very good for the market, because in the end, the prices will be a bit lower, and the customer stands to benefit. So I think, unless the context is a bit more clear, I would think that a cross licensing would not be viewed, unless it's a cross licensing between two giants who are existing in the space. But even then, the likelihood of the prices increasing, it is there. In reality, it's possible. But it's also possible that there's going to be healthy competition. So if the person who asked the question has more clarity on what exactly she expects, then maybe I can give her a more tailored answer. Uh,
I'll just wait for her to reply, ma'am.
sure.
So, Saida, if you can kind of clarify what exactly you're asking for, ma'am will be ready to answer. Meanwhile, we have a question from Dhruv, who's asking, what are the typical royalty rates in healthcare industry? Are your licenses largely in the US? And are royalty rates largely uniform across jurisdictions?
I think again a very good question. That's why like to talk to students, because they keep my brain cells active and alive. So a very important question. So royalty rates, how do you determine, right? It also boils down to valuation. How do you value your portfolio? So the valuation, if you go by the dictionary meaning, there are three different ways of valuation. For an R&D setup where it is a pharmaceutical, usually it's the cost of preparing a drug, for example, cost of coming with a drug in the market. And if you have a drug which is a new solution, which has got reduced toxicity profile, it has got higher safety, faster acting, lesser side effects. There are different ways to quantify how a drug is better than the previous one, right? And if you have a market for that, so we constantly hear that there are better and better diabetes drugs at the market, for example. You would then, a typical way of doing for pharmaceutical companies, usually they tend to adopt the cost approach, because the cost of development is so high that you want to get it in somehow, right? So if you license it out, you may want to base your royalties based on that. Usually for royalty, there is no, of course, there are indicative prices, but there is no really a rule book, because everybody can value it differently. I may value it differently. My customer may value very, very differently, because he has his own parameters by which he sees. Now, there are three typical approaches used for valuation. One is the cost, market, and the value. So, okay, I'll talk about the cost in the meantime. One is the cost I spoke about. The market is where you see that what are the competitors priced. So there's another similarly placed company giving its license away. It will have a certain royalty fixed, whatever the market prevailing rate or whatever. That's possible. And then there's another one, the third, I'm not getting the thing. Uh, it starts from I, but I'm not getting it. So that one talks about future earning opportunities. It's called the income approach. I'm sorry, it's called the income approach. Cost, market, and income. The income approach is mostly about if you are having a startup, for example, dealing with a new age technology, where it neither has a significant input cost, nor does it have similarly placed companies who are peers to that. Then you would base it on future opportunities. Okay, I have a breakthrough innovation here, completely disruptive, and I will put an X price. So long as there's no competitor anywhere around the periphery, this person can actually command premium profits from this, and people may still be willing to pay. There are technologies which are absolutely disruptive. You can charge royalties. Now, very important thing about how do you value this? Where do you, what is the price point that you decide? It all depends upon negotiation and what the other party is also willing to pay. So it's never, there's not like a formula that I will go with this and the other party will agree, because it's always a two-way thing. It's a negotiation that happens in these cases. I don't know if I answered the question through. Please, please feel free to ask me for clarification. Happy to do that.
I am sure you did, ma'am. Meanwhile, I think we have another question from Ashoka Kumar, who's asking how your company, as in his referring to Philips, decides in which countries the patents have to be filed.
Yeah, very nice, very important question. See, typically, we know our markets. Typically, for example, if I'm going to make an anti-malaria drug, if we don't do anti-malaria drug, I'm just saying for an example. Or let me take a Philips example. I'm going to talk about. So we have this mobile ultrasounds, small ultrasound which can be plugged into your phone, and you can view the ultrasound image. Okay. Now this will not sell in India because we have an act called PNDT Act in India, which prevents us from doing anything where the doctors have to be accountable. And there's a certain reason because it's called Prenatal Sex Determination Act, where sometimes in the past people have misused it for female feticide, and there is a history to all of this. You cannot sell such a device in India because the clinic has to say that they will follow the protocol, etc. There's a lot of checks and balances before you can have an ultrasound device sold in India, for example. If this is a handheld thing, the chances of misuse is very high, right? Now, we not only think from the customer perspective, as I said, we have to think about the prevailing legislature in the market. And we may develop this product in India, but we may not be able to sell in India, although there are customers, because the legal provisions don't allow us. Then we may look at another market which may benefit from this. So US may not be the right market because there they have a very good insurance system and everything. They would prefer to have something much more would say typical ultrasound machine, but this could probably sell in maybe countries in South Africa. It could sell in other regions where it's a very cost competitive market, for example, and then. So to answer the question, typically this thinking through about where are you going to file patents should actually start much before you develop the product. You decide where are your customers, who's going to buy this product, boils down to that, and accordingly your patent filing strategy will follow the same course, and you will choose those markets especially because if your market is in developing countries and there is zero market in North America or the Western Europe, you may not want to spend money over there. You may file the patent still. It's a decision thing. Okay, you can still license it at a later date. Sometimes you can foresee 5 years down the line, my product is likely to be sold. And that's a bit of an insight that comes from experience that you know that right now, no, but 5 years, yes. But because you cannot file a patent after 5 years because the novelty is already gone. You may strategically file now, but use that patent in that country much later. So you need to think through the possibilities.
Thank you for answering that, ma'am. And we have a reply from Saida as an extension. She says, for example, if both the competitors have certain patents that each one wants to have access to, how do we ensure that it doesn't attract antitrust oversight?
Say again, actually, I don't know if it's there in the chat. The same question. I missed one line. So, competitors in.
Ma'am, I'll repeat the first question and this so that you will have context. So, initially, she had asked in cross licensing deals with competitors, what
Yeah.
are the things to keep in mind so that we don't violate the antitrust laws? So, in extension, she says, for example, if both competitors have certain patents that each one wants to have access to, how do we ensure that it doesn't attract antitrust oversight? I mean, what are the clauses of agreement we should keep in mind while doing so?
Well, see, antitrust is what the government comes and tells you, right? Or somebody else could file a complaint saying that there is market monopoly over here. But when it is just between two companies, for example, it is a GE and a Philips who are having this cross licensing, You would want to just put, you would want to define your markets, for example, that you don't step on each other's toes because you're licensing, this person is licensing, or you may have certain agreements in that saying that you will specifically sell under this trademark only. Or I will sell XYZ products and you sell the others, although the underlying components in the technologies may be very similar, because one could be higher end customers, but the market may be smaller. Another could be the lower end customers, but the market is larger. So in the end, they both get equal shares one way or the other. So it depends on a case to case situation. The antitrust usually triggers when there is a feeling of dominance that nobody else is able to enter the market one way or the other. But if you're saying that it's a non-exclusive license, then I can license to anybody else tomorrow. I may have a cross license with somebody else. I'm not binding my license only to this company. I am also saying that this is a nerve that is non-exclusive, fully, the license where I will say that I'll give it to you tomorrow. If a third company comes to me, I will, on similar terms, give a license to them also. Or I mean, of course, it's a call unless it's a FRAND license. You can have little up and down. You can have a differential licensing arrangement because the marketing setup of one company is very broad. For example, you know that you will get, although you are licensing terms a little low, just by the economies involved, you may still get your licensing revenue. Whereas another company has got a different market where they don't have such a big marketing network. So you know that they're going to give you lesser. You have to structure your deals accordingly. In the end, so long as you can prove that you're being fair, I think it's not that big of a problem. At the end of the day, you have to say that you have not kind of violated any of the antitrust norms. You take care of it, you're kind of good, I think.
I hope that answers your question,
I
Sai.
hope so too.
We have another question from Rohit who asks, do you agree that SSPPU is the appropriate royalty base for FRAN royalties for cellular SPP?
It's very important to understand. We see a lot of these things floating around in the market. Implementer will come and say SSPPU is there, and you have to pay as the smaller swelling component. You go to the market. So I'm just talking about how to answer this question in a proper way. Is suppose you have a Mercedes Benz, okay, and you have a certain component in it which is there, a certain feature in it. You may not use the feature at every given time, but you're buying the car because it includes that certain feature in it. Okay. Now, this may not be the condition in everywhere, and this may be different for automotive, it may be different for cellular or whatever. At the end of the day, if this is not implemented on the chip, or it's not implemented in a certain aspect of the product, then usually the royalty rate is based, I think internationally, I think even in Europe, and the way the jurisprudence is developing everywhere, it is the device level where it is done. Because if you start doing at a smaller component level, it becomes very, very difficult to manage it. Now, what the royalty rate should be is a different topic of conversation versus which aspect of the device it has to be based upon. They are very different conversations. But you can have a different royalty rate based on differential arrangements so long as it's FRAND and whatever. There are a lot of nuances that go into SEP licensing. But you can say it should be based on the smaller selling unit. But if the device itself is depending on that, it's not depending on that particular unit. You cannot base your royalty on that smaller selling unit unless you are able to actually prove that it is that component which is responsible for the whole device, which is very rarely the case. Almost never is. Because there are so many aspects of software that go into it. There are so many things that go beyond just one component in a product.
On that note, I would like to add that we have a speaker talking about on brand post lunch. So I'm
Yeah,
sure Sir will be able to contribute more on this as well. So, ma'am, if you would like, there is one more question we have, and it's a very career-centric question.
certainly.
So, someone, Disha Soni asks, if someone wants to join in-house corporate, can you suggest what areas and skills should one work upon? I think this will personally be useful for me as well.
Well, what I tell most youngsters is you can always learn things, right? As human beings, we are basically having some intelligence. You will learn things. What you don't learn typically is your attitude and behavior. And that's my advice to all youngsters, including people in my own family, is that what will get you employed may not be as much as your skills as it's your attitude and behavior. I think it is the most important trait. How you conduct yourself, your ability to, I would personally think is not to say no for anything. Because if you are an enabler, if you are a person who's willing to take risk, if you're a person who's willing to learn and learn on the job and deliver, you may not know everything the day you join a company or the day you even go for an interview. But it's very important to have the, what do you say, the inherent quality of having the urge to learn, right? Learn and do things on your own. Okay, there are challenges, there are failures that will come, all of them will come. Ability to face them with an attitude, ability to behave well with your colleagues, ability to get along well with larger teams, being a team player. I think these are priceless. Rest you can teach. You can teach anything to anybody. Uh, just my 2 cents on this.
Thank you so much, ma'am. That was indeed helpful, like, even personally for me. So I think we have no more questions, and that was really an insightful session from you. Do you have any concluding remarks, ma'am?
No, I think it's a great initiative which is being done by NASA, and I think it's a wonderful effort that they're doing in terms of reaching out and the mix of the people that this conference has in-house faculty. You have also people from the corporate. I think it's very good because the students who are now listening in, they can probably choose which side of law they want to take. They want to be practicing professionals in the court doing the rigor, or they want to be in corporate, kind of, it's a different setup, comes with different challenges, of course. But I wouldn't put one over the other. Both are very exciting. I have done bench chemistry. I've been in the lab. I've also done in my earlier stages, I worked with lawyers too, and there was no day and night, to be honest, but I learned a lot during the time. And I'm not going to say anything about it because that actually taught me a lot of things about time management, about the rigor of the profession, about conducting yourself in short time. How do you maximize your efficiency? And these, I think, every stage is important. I think at every profession is equally important. You may go into another thing a few years later, but that moment, whatever you're doing, I think it's very important to enjoy it the most and learn whatever you can in every instance. You never know when it will be used later. So these are my closing remarks. And I hope I could maintain the timing. Was still okay, I hope.
It was perfectly in time, ma'am. Thank you so much for your closing remarks. And we hope that you continue to stay with us after the lunch sessions as well.
Yes, I want to hear what Murthy says. So we'll
Perfect.
do
Thank you
that.
so much, ma'am.
And thanks a lot for your time. And again, congrats for the wonderful event that you're organizing. Thanks
Thank you.
for the opportunity as well. Thank you.
So, our pre-lunch sessions now conclude, and we will be breaking for lunch, which will be a 1 hour period. So from 12:30 to 1:30, we will be on lunch, and we will start back at 1:30. During this time, I mean, before we do break for lunch, I would also like to inform that I have sent Google form links, which are feedback forms for you to fill, all the attendees to fill. So please feel free to go and fill the forms. The same form will also be sent to you via emails while you receive your certificates. So any doubts on the certificates or forms, I hope I have clarified them. Thank you so much. I will see you guys after lunch.